Good afternoon. I'm Marilyn Smith, and I am a regional prevention specialist with the Lafayette Region Office of Community Services. I am a career child welfare employee, so I was around during that timeline of child welfare legislation. I was here when we had the Louisiana plan in 1980 in response to the adoption and Child Welfare Act of that year, as well as a subsequent years of legislation that has impacted all of our lives who've been working in this field, and certainly all of the families. I can say that over the last 10 years or so that I've been working in the field, that I don't think anybody would disagree that the rate of change that we've seen has been faster than at any other time in this system. Those of us who are at the front lines can really attest to what is going on now as being one of the most difficult things to deal with is the rate of change and how fast things are moving in a different direction. It's often unclear what that direction is or what the changes are constituted by, but what I'd like to do this afternoon is to give you a sense of what the changes in Louisiana's child welfare system as implemented in Lafayette Region are. My role as prevention specialist, which morphed from being a program specialist about 3-4 years ago, has been to serve as a liaison between the field office in Lafayette and the state office that has taken the position of launching a huge number of initiatives there. What many of you may have heard referred to as Focus on 4 in years past is part of what I'm going to be talking about. What Focus on 4 involves and the instruments and tools and philosophy and practice changes really constitutes a huge sea change for the way we do business in the agency, and most of us haven't quite assimilated all of the changes yet. So I have quite a lot of material. I know y'all have been receiving a lot of material today. I'm very happy to be part of this group and the body of knowledge that's been offered up till now. And I will try not to get bogged down in too many of the excruciating details on some of the instruments. Some of my colleagues will be relieved to hear that, I'm sure. I am an LCSW, but I've worked in virtually all the programs in child welfare. I did frontline child protection work. I worked in the previous incarnation of the statewide child protection hotline during its 18-month tenure back in the mid-'80s. I also did juvenile probation and parole as my first job with the system. I've worked in adoptions. I worked as a trainer. And I also have in the past years worked as a program specialist and district manager. So the benefits of working all of those programs is you get to see the system as a whole, and you start to look for those holistic trends, and you start to pick them up pretty fast. So what I want to spend some time talking about is, what kind of changes and enhancement we've seen in the system, especially most of us will recognize since 2005. And what happened there, of course, were the storms that Louisiana sustained, and the part of the recovery process for the child welfare system involved an infusion of consultative support, as well as some real money in the way of grants and other in-kind types of contributions that we received. But those post-storm consultations helped to clarify our mission in and align it closer to what the best practices across the country have been. And we were those focused on, when we talk about focus on 4, we're talking about getting back to what has been defined as the 4 critical roles of what child welfare is assigned to do, both statutorily by the Children's Code in Louisiana and by the federal statutes as well, but also in the public eye. What is it that our community expects us to do? And what you'll find, if you pick up newspapers who have a child welfare article on it, in it about some high-profile case that they don't usually talk about the ones we succeeded in, but the ones that we failed to keep a child safe are usually the ones that are foremost in the public's mind. In tandem with safety, assessment of safety is the assessment of risk of future harm. And that is also one of the critical functions that we as child welfare providers, service providers, are assigned to. When we look at what other skills we have on our radar screen, we look at assessment of family function also goes hand in hand with assessing those factors that involve safety and risk. Family function is a easy to say, hard to understand, hard to grok type of term, and it's one that we spend a lot of time in our agency reviewing and developing our staff expertise and skills in. The service planning function and the continued monitoring and evaluation of those service plans that we devise for our families are also very critical. And those comprise the 4 critical roles that what we've called Focus on 4 deal with. In addition to those 4 critical roles, what we've seen to the surface, or the surface level, in terms of what's happened in the child welfare system are some improvements in utilizing residential care, treatment, a focus on treatment rather than placement exclusively in a custodial type of frame of mind, accountability to licensing standards, improvement in our response to, in how we respond to reports of abuse and neglect from the general public, including a more standardized approach to intake, including after hours. And with that, we've seen the launching of the alternative response program for low-risk intakes or reports we get from the public that are possibly below the radar screen of what should constitute a full-scale investigation. In addition, as has been pointed out by several of the providers, we're looking at how we can improve connections. We know the stats with children who age out of foster care are not good. The state is a very poor parent. If we have not succeeded in connecting that child with some type of permanency or significant individual to be there for that young adult after they reach 18 and our statutory responsibilities end, then the likelihood that that young person will be incarcerated or in prostitution, as Ms. DeJean pointed out, be an IV drug user in prison, homeless, is extraordinarily and very disproportionately high. So we see children who are in foster care have a disproportionate representation in continued population groups that have poor outcomes. So we are working, we've had an infusion of programmatic expertise and consultation to make us more effective with that. We want to start earlier with our kids And we want to be more effective with our independent living processes and making those connections prior to the time that our statutory responsibility ends. Then after the statutory responsibility ends, we have what's called YAP, or the Young Adult Program, which we want to get all of our children, give them all the opportunity to take advantage of. It's a young adult program that gives them a launching pad between 18 and 21, actually up till 22, so that they can get the benefits that most of the children that we raise have. We know that we were not ready at 18, and our kids are probably not ready at 18 to launch themselves. So we're highly cognizant of the need for our kids to have that additional support. So in addition, what you will see is a consistent, one of the threads you'll see running through here is an emphasis on research and evidence-based practices. Part of that is something that relates closely to what Mr. Jean was talking about in terms of recruiting efforts for foster and adoptive families. We have now a very specifically designed, targeted recruitment system for recruiting foster and adoptive parents according to the ethnicity, the constitution of our ethnicity in our foster care population. Who are the children that we need to recruit for? We are looking in a much more specific way how we need to target those families. Who are the families that we need for these children? If we have 60% African American, then that should roughly be our goal for how we're going to be recruiting. And we have a very strategically supervised recruiter in every region who is going about very actively making presentations and with that in mind. Other enhancements to our service array. We have a Family Resource Center as a result of the Family Preservation and Family Support Act of 1995, which is our private sector partner. They provide a lot of the services as an adjunct to what our caseworkers provide. And we've recently seen an update in that service array to provide more targeted services to what is going to expedite the kind of outcomes that we want to see with our families. Those, the kind of services that you'll see the FRC providing include intensive home-based services. And we also have an in-house intensive home-based services. Who's heard of intensive home-based services? I know OCS has. But intensive home-based is basically the gold standard for family preservation, basically promulgated by home builders out of Seattle some 30-something years ago. That we're also using, in addition to family preservation, keeping high-risk families intact, we're also using them to prevent disruptions to families when a replacement might be threatened, or what we call disruption. We're also using them to expedite reunification with our families when we feel that the parent is making progress toward reunification, but we need to just have a little more affirmation that they are doing what they need to do to be protective of their child. And so intensive home-based services will go out there and spend an average of 10 hours a week to provide intensive, concrete, problem-solving, clinical, sometimes, skills for the family. It could be budget, it could be organizing, it could be a whole array of things. But whatever it takes, whatever barriers there are to keeping this family intact or expediting reunification, that's what they will do. Other advances include evidence-based parenting education. For us in Louisiana, we have relied most heavily on Stephen Bavelek's Nurturing Parenting program, which most of you probably have had some nodding acquaintance with. It's one of the more researched parenting education programs. Strengthening Families is another one that we use in this region for older kids. Nurturing gained its currency among researchers mainly with the 0 to 6 children. But what is involved with nurturing, if you don't know about it, it's a very exciting parenting education system where they give important developmental information targeting to the families, and it's structured to be, can be structured to, for the less sophisticated parent. There are some scaled down, less dependent on words, less dependent on, they have an easy model. I don't know if anybody has specifically been in one of the classes, but I've seen the parenting modules that they use with parents who aren't as literate as others, and they can target to one-on-one skills level with the parents to get them to the point that they are more protective. And what you're going to hear is a term called protective capacities. How can we increase those protective capacities in our parents? How can we assure that the reason that the child came into care is what we're continuing to provide services for, and not something else, as Mark Harris pointed out to me, a phenomenon that I hadn't heard referenced before, a case plan creep, which you can easily imagine what that might involve, basically to raise the bar to the parent after they get in. We need to be very specific in what it is we are targeting with the families. One new model that we're just in the process of launching across the state is called Visit Coaching. It's very exciting. It comes out of the National Resource Center for Permanency Planning and Family Connections, I believe. And Marty Byers is one of the primary proponents of it. It helps families helps our staff find ways to engage families better, to get them past that very difficult and stressful experience of having a visit. And most of us think, well, visiting your child, there's very little preparation you have to do for that. They just put them together in a room and you just watch them. But the reality of that experience is it is an extremely stressful event for the parent who has all this kind of reminders of this whole thing, just underscores that I was a bad person, I wasn't a good parent, and the foster mom is now taking care of my child, and she comes in and the child is calling her mama. And we think about, well, that's what visits are, but it's tough for the parent to get past that. And when we say that it's tough for a parent to get past that, what we're really saying is that it's tough for the parent to get engaged in doing what they need to do to get their kids back. So visit coaching is a very targeted way of helping parents become more on track with what they need to do. Separating the wheat from the chaff, separating the things that they can do constructively from the things that are not so constructive. In addition, we have multi-systemic therapy, which works with the adolescent population. LRAP, which was a product of a grant from the Brookdale Foundation to support grandparents. We know that disproportionality is one of the things that we see with minority populations. Grandparents sometimes are raising those children at a higher rate in the African American community. And I have a wonderful publication, which I'd be delighted to share with you electronically if you give me your email address, or maybe Ravonda would agree to do that. It's called the State of Louisiana Grandfamilies, State of Grandfamilies in Louisiana, by the Herzl Institute, that talks a lot about the state of grandfamilies and kinship care in the African American community. And the differences, differentially assessing how African Americans care in their extended family versus the rest of the community. Very interesting stuff. I hope that you all will take advantage of looking at that. And there is an awful lot of information out there on kinship care that is, we're just kind of just beginning to take flight on this. So I hope that you will do some exploration yourself on that. One of the other things that we've done that we're very excited about is that we have the addition of a Office of Addictive Disorders clinician right in our office, right on site in OCS. And what that means for us is that if you've worked at all in the field of recovery or addictive disorders, that it's very easy to make a referral and have a slip occur along the way. This gives us an opportunity to tighten up that wiggle room just a little bit so that you can walk your client right over to our OAD clinician's office and have her scheduled or have her meet the clinician for her assessment. And that assessor, Jean Fernandez in our region, is very attuned to not only what the addictive disorders opportunities are for recovery, but also she is becoming more educated about what that means for child welfare and maltreating populations. So it's very exciting to me, and I hope that, if any of you have an opportunity to consult with our clinician, I hope you will use her to your full advantage. So as we look at, these comprehensive changes at every end, from the preventive end to the exit end, and all in between, looking at how we're targeting families for adoptive and foster recruitment, looking at prevention and reasonable efforts, how can we make this system more aligned, more consistent, more reliable, accountable, effective, and fair, and ethically appropriate? When we talk about, I think these are all potential pitfalls when we talk about disproportionality, because when you look at consistency, are we doing the same thing from one end of the system to the other? Do we have an outcome in mind? Do we want the best outcome for our children? Are we working for the same types of outcomes in picking up the phone and taking a call from some person in the general public to helping a child get launched into being an adult in the community? But do we respond differently to different groups? Are we doing what the statutes require us to do? And what does the statute require us to do? Primarily keep children safe. It also requires us to keep them in the least restrictive placements, which means reasonable efforts to assure that they get an opportunity to stay in their families. It means that we are systematic in the way we do business, as opposed to just operating from a platform of goodwill, possibly, which is also an important thing, along with empathy, empathic skills, that we have a systematic response. That we have decision-making that is aligned and systematic, and that we have these junctures that we understand that families will go through. We've mapped out what are the critical junctures here. When we look at consistency, we want to make sure that all families have equal access to services. And that whole phenomenon of raise the bar after the family comes into the system, we want to minimize that as much as possible. What happens, for those of you not as familiar working with families, we get a report on child endangerment from inadequate shelter or drug dependency. And we start getting a flood of information in, and we know everything about that family. Well, all of a sudden our antennae are up, and we are just sort of thinking, well, that could be a problem, and that could be a problem. And we're really failing, in many cases, to assess whether this is really keeping this family from being together. So we want to continually evaluate all of these dimensions of the way we do business in child welfare. We want to, by accountability, we want to make sure that we are honoring the standards of practice that 50 years now since the Dr. Kempe battered child syndrome in about 1960 sort of launched our whole scientific approach to child maltreatment. We want to take those 50 years and do something with it, have a sort of higher level of intelligence to honor all the conviction and principles that we've seen throughout all of our careers, those of us who've been around long enough to have a career could see. We want it to be fair. And that means that families have a chance to have their voice heard. And I heard that a number of times from some of the respondents. Will our families have an opportunity because of their lack of sophistication, or because they are not on board, or they may be alienated from who we are as a government agency trying to help them, that they may not be totally trusting in our intentions or efforts. We know that equitable treatment is something that is not only an issue across ethnicity lines, but across, as many people have mentioned already, across economic lines. Poverty, families with poverty are much higher risk. I have heard it said many times that we do not remove children due to poverty, but I'm not sure I believe that, because I think that the representation is much higher in those families who are more visible and more reliant naturally on the public sector for their everyday sustenance. We know that single families, those families who are relying on kinship care, also are maybe in that more visible sector. And then ethically, again, when we talk about going into a family's life in a very intrusive way and launching a child protection investigation, and they don't necessarily invite us in, we have overridden their right to privacy that most of us in this country value very highly, and said the law gives us the authority because we have reason to believe that a child is endangered. The law is very specific in how it authorizes us as well as limits us. But when we do go in, we need to be respectful of the quid pro quo principle, that when we take something away from anyone, an individual or family, that we need to replace it with something. So if we are intruding on their right to privacy, what are we going to replace it with? And how we engage that family is one of the things that we need to be much more mindful of and have much more clearly proscribed strategies for how we're going to systematically, if you will, engage that family. How are we going to collaborate with that family? How are we going to let them have a voice at the table? It's not the easiest thing because you're dealing with a lot of factors. They're involuntary. They have a lot at stake here. The most precious thing that they have, in many cases, the most precious thing that they have produced, the thing that they identify most as an adult. I have done it. Look what I did. This is my child. They may have been wonderful, courageous things with that child that we have not been privy to, and yet we're seeing them at this point of crisis, and so this is the straw that breaks the camel's back, and we don't know what we haven't seen. We don't know how protective that family might have been in the past, and we need to be exploring that when we go into a family's life, when we take them apart through our investigative and and service planning process, we need to make sure that we are honoring their own systems and trying to sew them back up a little bit, give them the opportunities to heal themselves a little bit. So when we talk about Focus on 4, what we're talking about some years back was a conscious decision and commitment by OCS management to assure staff competence and recognition of staff competence in carrying out these 4 primary responsibilities of assessing risk, safety, family functioning, and the case planning and assessing process. This is a slide from the Children's Resource Center, Research Center, as a 3-legged stool that we need to sit on. And it's a 3-legged stool of best practice is the way I see it. What the Children's Research Center says is that we need to rely on this 50 years of research that we have, along with structured tools and our clinical judgment, that we need to use all of these, that relying too heavily on one is not going to serve anyone well. So we've, in the past, have tried to develop the skills of our workforce and of, individuals. I know when I went to do child protection, I was very deathly afraid of what I did. I was keenly aware of what I did not know about the field, which caused me to go back to graduate school. And I still haven't learned everything I need to know, but I know that I can't know it all. There's nothing that I can just pour into my vessel that is going to be completely enough. That's why we have a shared decision-making process in OCS, and that's why we have to rely heavily on each other. All of our partners, not just in the agency, but all of our community partners, to provide us with eyes, ears, expertise, guidance, perspective. That's why we can't do this without our families. And then the structured tools. So I was glad to hear someone mention SDM. It makes me feel like I don't have to spend too much time on the SDM slides. You have the SDM tools in your handouts. I hope you will look at them at some point, but I don't want to spend time today going over them. But the structured tools, for me, are a big deal. But again, you can't rely exclusively on the structured tools any more than you could rely on the exclusive skills of Michael Cedar or Marilyn Smith or Wanda Smith or Brad Richard. So we are dependent on this interdependence, and I like the idea that we have to check ourselves. Part of our system has to kind of check us once in a while to make sure that we are looking to the places that we need to look to get the answers, to get the solutions we need. So we use the Form 5 for child safety. It is a nationally validated form. We've used it for years. It assesses 14 factors to determine child safety. It was, I believe, developed by the American Humane, which has been widely accepted as the foremost authorities in the area of child safety. The structured decision-making model is an actuarially based tool. And I don't know how much you know about actuaries or actuarial tables, but if you've ever had your insurance calculated, if you've bought term insurance, I guess, where they will calculate, or if you've gone to get your retirement calculated, they will look at who you are as an individual, sometimes your health factors, your age, your gender, sometimes where you live, to make a determination on what the risk, how big a financial risk. It's amazing to me, and I saw it in the movie this morning because they talked about financial risk. The use of the calculation of financial risk has been in use for, I don't know, probably hundreds of years, at least 100 years. The fact that we are using the tools or some of the strategies to calculate financial risk in the area of child maltreatment, to me, is kind of revolutionary and a little bit exciting if you've worked in this field for a long time. The two primary goals of SDM are to reduce subsequent harm to children and expedite permanency for children. When they talk about reducing subsequent harm, they're talking about a period of 18 to 24 months. It's highly structured based on the research that they have done regarding re-referrals to investigation, substantiations of child abuse neglect, injury to children, foster placement, and then expediting of permanency. So this is just basically about actuarial risk. It's an actuarial table. Some people argue that, and I have an article, I have some literature here if anybody wants it. I can also email that on the discussion of disproportionality by the Children's Research Center, and whether, there is possibly a little, it may be subject to continued argument about whether actuarially based tools are effective in reducing disproportionality. But that is one of the big contentions of the Children's Research Center, is that it is highly equitable, that there is equity across ethnicity lines in the way our decision making is applied if it is used. Now, I will qualify. When you use the SDM tools, it's imperative that you go exactly back to the definitions that they have. You can't make up the definitions as you go along. You have to revert back, and these are web applications, so when you go online, you fill it out and you can press on the icon and it will show you what the definition is. But you can't just kind of, this child hasn't been diagnosed with failure to thrive, but she sure seems like it to me. It's not going to be valid if you try to do it that way. So we're really working on trying to get workers to be very loyal to the model and maintain that fidelity to what Children's Research Center has outlined. We complete SDM every 90 days. At the initial, we complete it. Now we just started about 3 months ago, introducing SDM in the child protection investigation phase. Before that, we were doing the initial SDM at the point of transfer to either foster care or FS. There is a move, and I don't know where it is now. I haven't heard anything lately about it, but they're talking very intently about structuring our intake according to SDM principles. That is, by my understanding, due about the first of the year, sometime after the first of the year. Right, Karen? Okay. Well, we'll find out together, but that's the last I heard on that. And what the SDM does when you complete it is that it's 2 dimensions, one according to abuse and one according to neglect, and you can look at the pages there. There are the different types of SDMs there. Calculates it based on abuse and neglect and totals a score. And by that score, it gives you the likelihood, the probability, according to the research on the factors that have been identified by Children's Research Center in their previous studies, what the likelihood of maltreatment in the next 18 to 24 months will be. So we have low, moderate, high, and very high. We are also, one little other fly in the ointment is the economic issues that have all created a climate in which we're all doing more with less. And as a result of that, we are seeing a need to how we can target our resources more effectively. And SDM will allow us to do that, because if we see a family that can benefit more from our services, the thinking, the sense is that we should prioritize, we should give them the opportunity to get those services. If we have low and moderate families who will not benefit or benefit less from the services, then we may refer them to community-based services as long as there's no safety issues. Safety, of course, is on a separate track. There are safety issues that the child can be removed, and that is, of course, what guides whether the child would be removed or not. So we're looking at how our decision-making can be guided as a result of these SDM calculations. That would be at the decision-making on whether to open the case in family services, foster care, and also every 90 days. It also influences how often you'll be required to go out and contact the client. A very high risk in a family services case, for instance, would be 4 contacts per month with the parent and the children. And each level has an assigned contact requirement. Okay. So again, the results of targeting our resources are that hopefully families, high and very high risk families, are significantly more likely to experience subsequent maltreatment, so we should get them the services. There's some slides here which I'm not going to go over a whole lot, but you know, the reliability, validity, equity, and utility of all of these instruments has been validated by Children's Research Center, and Deidre O'Connor is definitely the go-to person to explicate more on that. Different decisions, different assessments, differential diagnosis, differential way of looking at families, tailoring it. This is an assistance to us. Here's one of the slides on the equity in the risk assessments and in the subsequent substantiations. Another slide on the equity and risk assessment, that it's consistent with the constitution of the population. Okay, these are all, I could go down a little more. I want to spend a little time talking about the assessment of family functioning, which is once we accept the family into services, we have a whole lot of material that follows that. And I want to dispel the notion that there is a logic and a sense to how this document was devised, and not that, you know, it was sort of blindfolded people in state office at a computer randomly putting together a form and a web application for us. But it's been a little less straightforward, shall I say, in launching the functional family assessment. SEM is very straightforward. The functional family assessment, which is found on the Family Assessment Tracking System, otherwise known as FATS, is less straightforward and more highly dependent on the skills of the individuals. More highly dependent on engaging the families. Engaging families allows us to understand their strengths and protective capacities. And some of you may recognize, I know Judge Brown has had some dealings with Lori Lutz, and a lot of this material comes directly from Lori. She substantiates that while we tend to think of engagement of families as more as a soft, non-evidence-based type of practice issue, she substantiates in several items here that it is, au contraire, very evidence-based and very much best practice as validated by a number of studies. And I have a lot of that here. She says we have to look at, we needed to work on it more than a historical compilation of information on our clients, where we get all the hospitalizations and all the discharge summaries and all the psychologicals that have ever been done on a client. We need to focus on what their strengths and needs are now that are contributing to diminished protective capacity. That's basically what our role is. And she says that 55% is us correctly or more accurately assessing the strength, the places of strength in this client, if they ever cared for that child well. And 30% is the relationship, which is, you can imagine with our workers taxed the way they are, it's difficult for them to put that on their front burner when they're really focused a lot on completing forms ad infinitum and many times ad nauseum. The reference is a Dr. Barry Duncan. I'm not familiar with his work, are you? But she says that from a strengths perspective, and when you know, strengths perspective is a pretty radical way of doing business in helping fields, because we, rather than the medical model or a diagnostically based model where we say, well, this is a borderline personality disorder or childhood schizophrenia, we need to be assessing what are the things that they are able to do, what's their functioning level, the functional family assessment. So when we are able to identify strengths, which is sometimes very hard for us, given the angle of entry into this family's life, which is usually precipitated by a crisis. 55% of the motivation to change comes, and the ability to change comes from focusing on that place of strength and the relationship that is formed with the helper and the client. And 15% is hope and expectations. I wish I could explain it more because I really don't have the background on this one. She cites many other studies, however, and if you like, I can get you the details on this through Ravonda. Okay, I'll work on that. Of course, when we engage families, we're more successful keeping them in the home. Lori, I remember when she came and did our training, said that there was a study about child fatalities, that there was some, I can't remember the exact quote, but it was so many, a high level of them occurred in cases where the worker had made up their mind in 15 minutes over what the issues were with the child, with the family. And I don't know, it's probably not a good strategy for me to cite a statistic I don't have the full benefit of, but her message, the takeaway on that is, the snap judgments, they're not good business. They don't work, they're not accurate, they don't move families forward. So what we are tending to focus on is how we can mobilize protective capacities. That is what is missing when it's a more of a wellness approach. But when we identify a child who is at risk, what we're saying is that family, the protective capacity is reduced, diminished. So we complete that assessment within 30 days. It's a long document. We use we have 8 domains we assess to include. We don't include all of the domains, though, in the service plan. The service plans that you see for your children are ones that have been hopefully targeted already, the real issues for safety and risk with the child. And these briefly are the domains that we look at: family violence, management of child behaviors, day-to-day parenting skills, child physical, emotional, developmental issues that require day-to-day care and intervention, child's educational, vocational, independent learning, child substance abuse visitation plan outside the home. In addition to substance abuse of the parent, the mental health of the parent. There are many other domains. There's 8 in total. And I'll be happy to provide anything else to you. Important takeaway on this is that we are really working to develop staff skills in behaviorally stating the service plan so that the parent knows it's not kind of obscure and too sophisticated for them, that it's sometimes using even their language to arrive at what it is that the family needs to do to accomplish the goals of getting OCS out of their lives, having their children return, whatever the outcomes are. And there's many, many other things that we could talk about, but I know that you have another full agenda. Is there anything else I can say, answer by anybody? And thank you for the opportunity to get this word out.
Good afternoon. My name is Joanne Brown. I'm a retired judge from California. I am a consultant for the National Resource Center on Legal and Judicial Issues, which is one of 11 national child welfare resource centers that provides technical assistance to all the states in the United States and the territories regarding issues having to do with child welfare law, court improvement, and court practice. One of the most important initiatives that we're involved in currently, and this is actually the second year that this has been a priority for the Children's Bureau and for the National Resource Centers, is the issue of disproportionate minority representation. I'm particularly pleased to be working with Louisiana and the Louisiana Court Improvement Project in this program because I see some tremendous effort here and community involvement that frankly we're going to try to use and multiply as we work in other states as well. The work that's been going on here in the 16th JDC is really a model not just for the rest of Louisiana, in my opinion, but really a model that's transferable across the state, and you all are an important piece of it by participating here today. I'm going to be talking about legal ethics. My colleague Rika Quintua is going to be talking to you about professionalism later. This ethics presentation or workshop is going to be divided into two parts. I'll be talking about ethical standards, and I'm not just going to be talking about ethical standards for attorneys. I want to remind us, even though my focus will be on ethics for attorneys who practice specifically in this area of the law, that in this particular area of the law, unlike, in my opinion, any other area of the law, we come into contact with an array of professionals who bring with them, as we do as lawyers or judges, their own bundle, their own set, their own constellation, their own framework of ethics and professional ethics and standards of professional judgment, standards of professional decision-making, standards of professional analysis, and as importantly, their own language. So we'll be talking about primarily the ethics of attorneys and attorneys' practice in child and abuse, CINC, child in need of care cases or child protective actions. But I want you to keep in mind, and I'll try to remind all of us as we go along, that we really have a whole array of professionals whose ethics they bring with them in their interaction with us and the families that we all work with. The second part of this workshop will be about DMR as an advocacy tool. And when I say an advocacy tool, we typically think of attorneys. I'm thinking of advocacy for CASA volunteers. I'm thinking of advocacy for social workers. Social workers, as part of your ethics, are advocates to correct social injustice. Okay. I want to look a little bit more as we progress about the unique issues that come to the environment in which we work when we work in child protection or child in need of care cases or child protection cases. Ours is a very different court culture. Now, I alluded to that when I said we have a lot of different professionals. But just think about it, okay? When you go to criminal court, there's the judge, there's your client, there's you if you're a defense attorney, there's the district attorney on the other side. It's all very neat. Okay. If you go into civil court, there's the judge, there's a bunch of attorneys. They've all got briefcases and suits on. Then there's a bunch of attorneys with briefcases and suits on the other side. Until you are in trial, you likely don't see in either of those circumstances much more. You may see some more lawyers on some other cases. You might see some police officers. You might see some paralegals. But what you don't see are little kids, parents, foster parents, third parties unrelated biologically, some third parties related biologically, family members, maybe another family that's either out there, or if you have an open or you don't have a sealed or closed proceeding, they may in fact be in the courtroom at the same time that the case is going on. You may have social workers waiting for their case or waiting for other cases. You may have a toxicologist who's waiting for his case to be called to testify about a report regarding the drug test. You might have physicians, you might have psychologists, you might have a school educator, someone from the schools there who's testifying about the educational needs, excuse me, of this child. It's not neat. It's not tidy. And most of us, my generation or even younger than my generation, we didn't learn this in law school. This was not one of the courses you took in law school. It even wasn't a clinical for most of us. You know, it was criminal, civil, tax, make money law. That was about it. Okay, and for those of us who knew where we were going, we managed to ferret our way through law and to get to the goals that we had about what our profession would be. We didn't learn about representing youngsters. We didn't learn about the complexity of federal and state regulatory law and the overlaps. We didn't learn about how do you cross-examine when you have policy and child welfare policy that comes from 4 different funding streams. And that was the impact on a service plan if you can't qualify for Medicaid, but you can qualify under some other category. And does that mean reasonable efforts weren't exerted? That wasn't in the curriculum. It's barely in the curriculum now, and hopefully with expanding clinical programs we'll do better. So when we talk about ethics in this particular area of law, we have to look at the context in which we work. When we talk about DMR, we have to look at the context in which we work. We have multiple interactions and with professionals with different codes of conduct. One of the areas that always comes up when we talk about the code of ethics for attorneys in the context of child in need of care cases or in these courtrooms is the question I'll get from social workers. And they'll say, it takes a while though to kind of warm up, and they'll say, what about cross-examination? The attorney knows that the client did X, Y, or Z, did something that put that child at risk or those children at risk. Why am I getting such a hard time? Why is my integrity and whether I crossed every T and dotted every I really becoming the focus of the case rather than what the parents did or didn't do? Now, and they're clear, even though intellectually someone may explain to you that's what a lawyer is supposed to do, is to test everything a witness says, including the witness's credibility, it still feels crummy. It still feels crummy. And one of the things I want to remind you of today and share with you a little bit and talk a little bit about is the reason why we have as lawful a country as we do is because we do have codes of ethics for our professions, and we have people who try the best that they can do to live up to those codes of ethics. One of the reasons in which you have, and we'll talk about zealous advocacy, is because that's the advocacy we would want for ourselves. We would want an attorney who did everything he could or she could to find out everything about the case, all the facts, all the witnesses, and to test every part of the allegations or the evidence that was being used against us. Now, cross-examination doesn't have to be cross, and frankly, I think the most effective cross-examination is when a relationship is established between the attorney and the witness. But nonetheless, it has to be zealous. It has to be zealous. Otherwise, you have an attorney who is violating his or her ethics. And I suggest to you that all of our jobs will be better by all of us doing our jobs better. I mean, the analogy of the three-legged stool is exactly correct. We know from research now in 2 states with longitudinal research, which means over 5 years in these cases, that improved representation of parents results in more timely outcomes for kids. That means earlier relinquishments, more complete or earlier reunifications, earlier placements with relatives, less returns, less reabuse when families are returned so that they are living together, earlier permanency, less TPR hearings that are continued way into the future, and fewer TPR hearings. The state of Washington has adopted this model statewide because it was so successful when they piloted it. So to the extent to which improved lawyering results in improved outcomes for children, we have to support lawyers who operate with the highest level of ethics and the highest level of zealous representation. Language is important. We've talked a little bit about language. I'll talk some more about it. Our colleagues have ethics. These are just some of the lists of our colleagues I wanted you to keep in mind. Social workers, CASA, other professionals, law enforcement, judges, and lawyers. Let's look at the National Association of Social Workers. The reason why we have a juvenile court in Chicago at the turn of the last century came out of, as we all know, SPCA, right? Society for the Prevention of Cruelty to Animals, which was then translated into early social work practice and projects that you've all heard about and remember from your history books, such as Hull House, and the early, really, really fundamentally creative, hardworking, ingenious social workers in Chicago. They are the ones who effectively became the political lobby that said, kids need to be treated differently. Come on. You know, we're doing worse for kids and we're saying we're protected. We need to protect their rights. That's where the juvenile court came from. So there's a fundamental linkage there, and it goes right to the first of the stated ethical principles about NASW. Our primary goal is to help people in need and to address social problems. You will see in the NASW ethical principles a dichotomy, not a dichotomy like an either and or either or, but a both and dichotomy. The ethical principles that guide social work in this country, as adopted by the National Association of Social Workers, is individualized, it is relationship, and it is societal. Look at number 2. Social workers shall challenge social injustice. I mean, that is a really profound mandate. It's not, I'm just going to do a good job here and, you know, and work well with my families and my colleagues and get my CLE units. It's I have to have that broader vision. The others will seem familiar to you because that's the way when we contact social workers and we see social workers and caseworkers, we know them because they are relationship oriented. We know that they do try to behave with utmost integrity with their clients. Now, it doesn't mean because you are acting trustworthy that you're going to be trusted all the time. Trust is something that has to be earned. Like when you meet somebody newly, you know, do we give them the benefit of the doubt? Do we give them some information? Likely to be somebody we trust, they have to earn it in some way, or at least not do the contrary. So even though social workers are required to act in a trustworthy manner, it doesn't mean that will always be received. So it's a constant challenge to do everything we can in a trustworthy way so that we can establish that relationship. One of the examples of what number 5 speaks to is Marilyn Smith, who we just heard here, and also Michael Cedar from this morning. I'm not sure they're both here, but in any event, they're honored in there you are. We are honored in our words and in you and your presence. These are 2 real social work professionals, and I'm sure everybody else here in the room is just the same. What did you see from them? You saw from them dedication, you saw intelligence, you saw analysis, the ability to admit that we can do better, which comes with a certain humble acknowledgement of we didn't do so good in the past, an acknowledgement of I want to learn, an openness, and a very a professional narrowing of their level of expertise to say this is what I'm an expert in and I don't claim to be an expert in everything. That's why we have research. That's why we come to meetings like this, so we can gather up the expertise of other professionals. I think that's one of the areas in which we're kind of muddy, And I'd suggest that in terms of advocacy with attorneys, that when you have social workers on the stand or social workers presenting their reports, that you be very careful that you help them not go over those ethical barriers of what they can testify to as an expert with. And whatever the rules of practice are and the rules of evidence having to do with social worker reports here, I would suggest that the attorneys need to make sure that the basic rule of hearsay is protected nonetheless, because even though there may be an exception for a social worker's report, nonetheless, the report still has to be trustworthy. And that's where your advocacy comes in, because there may be components that aren't and components that are. Let's look at CASA, our good friends from CASA. Okay, CASA is a new animal too. So when I was talking about the culture of the courtroom and how criminal is so simple and civil is so clear, and then we have this array, this United Nations of people in a juvenile courtroom, okay? CASA is another entity there, and a vital entity. It needs to physically be there in the courtroom. We don't see that in the civil and criminal calendar, in the average calling of a calendar. It's another extraneous person. They're not there with a lawyer. They seem to be talking to everybody. How can they do that? We've become accustomed to it, but just think how odd it is from the outside. Okay, so it's another, another sort of interference, another wedging of ethical barriers. How do you talk to a CASA with maintaining confidentiality? What kind of confidentiality should you maintain? Can a CASA volunteer be cross-examined? Probably. So that means you have no confidentiality in what you say with that person. What about as an attorney? How much can you share with a CASA volunteer? How much should you? How do you make that determination about what's in your client's best interest? How do you measure that you're not betraying some confidentiality in your attempt to coordinate with the CASA or to work with the CASA for the child you're representing? It's a different person from the normal set of fixed relationships that we experience when we go to court. And it requires a real thinking through of what our ethics tells us to do. Okay, so CASA, you're fortunate here in Louisiana, and I'd say probably about half the states have it. You have an empowering or endorsing statute. And 424 says something really, really important about CASA volunteers. In many states, the law will say you are to provide an independent report to the court, and they'll have some provisions about protections and how you get appointed and maybe some access to records. That's different from what the mandate for the CASA volunteer here is in Louisiana. In Louisiana, you must advocate. You must advocate for the timely placement of children in permanent, safe, and stable homes. Sounds like safety, permanency, and well-being, doesn't it? Sounds like the same principles to me. And you must advocate. Now, what advocate means to me, you're not silent. I mean, I've never met a CASA volunteer who was silent. So just in case you have a CASA volunteer somewhere who's silent, you might want to find out how they think about what advocating is about. Statutorily, their ethics require them to advocate, and advocate specifically. Now, I also put up a couple of other ingredients to when I think of the ethics of CASA. So here I'm kind of stepping out into generalities. One of them is a personal commitment. Their ethical mandate when they sign that contract to be a CASA volunteer and make that commitment is a real commitment. It's not, I'm going to come and see this child when I feel like it. It's not, 3 months or so, or maybe a month, or then I'm going to vacation, and It is a real commitment of time and consistency and involvement and learning and appreciation and study and communication and maybe learning things you don't want to learn for a period of time, be it 18 months, 2 years, and I've seen CASAs go on for 4, 5, 6 years and beyond when that youngster was out of care. There is an accountability to the family and to the child. There is an expectation of the court. Now, I'm sure that Judge Porter establishes his expectations of his CASA volunteers, the ones who come into his court, very clearly. Some judges don't do that. They're not as kind to their CASA volunteers. They don't make it clear that they expect them to be this loud, clear, consistent, well-informed voice for the child. So I'm suggesting to you that maybe that's something that as a CASA volunteer you have to really look at yourself and saying, am I doing the most to advocate that I possibly can? The accountability to child and family, I put in there as something I'm seeing more and more with CASAs, and I think it probably fits in with where OCS is going here, and certainly the evolution in this judicial district. We are learning more and more from research, something that we've already known, and we know intuitively as human beings, and that is that family is important. Good, bad, otherwise, raggedy, disrespectful, bad jokes, bad food, you know, it doesn't seem to matter. They're still there. It's like Thanksgiving is a constant reminder of the wide range of family. And we somehow, I don't know how it happened, we kind of lost the track, I think, in translating what we know, and what we know from research, with what we do, with how we handle the notion of a child may have feelings about their family, the same way that we hope our children have feelings about their family. So a CASA volunteer's role is very important in what we are beginning to appreciate, I think, as an area of law and an area of practice more and more, is that those family connections may be the only stability that that youngster has. That youngster doesn't have a home anymore if that youngster has been removed, at least a physical home. So the only home they may have is that internal sense of identity that comes from knowing an uncle, an aunt, or a third cousin, or a fourth cousin, or a 12th cousin, or somebody who they thought was a cousin who was really a neighbor down the street. That's such an important role for CASA volunteers when CASA volunteer looks at really speaking for that child and working in the best interest of that child. What about judges? Judges have a role too here when we talk about ethics. I'm sure these are all familiar to you because we know what judges do and we know what Judge Porter does here. There is a focus here on a couple of really important, and you'll see the language repeated in different ways, dimensions of being a judge on the bench. Integrity comes across all the time. The court has a responsibility, and each judge has a responsibility to maintain integrity in how he or she deports themselves. And that means not just in terms of in the courtroom, on the bench, but that means in the community. The canons are very good about urging, particularly in the juvenile area, that judges step outside of the bench and outside of the robe, as Judge Porter does here in this judicial district, and really engage in those activities that will improve the administration of justice. Classic example, participating in and leading a multidisciplinary workshop here today that takes on one of the toughest issues that we all face, which is good decision making, making sure that our decisions aren't affected by race or ethnicity, and doing the best we can for children. And families. He is stepping outside that courtroom to come here and share with you this priority for him in this judicial district, and share with you his own personal feelings about being on the bench, the challenges of being on the bench, and his own analysis of how we deal with families and children, how race may impact our decision making. The other dimension that I think is so important, and when we look at the Code of Judicial Conduct, is not the decision making itself, period. When we look at sanctions against judges, okay, nationwide, the sanctions come from not what they say, but how they do it, which is the challenge, I think, of all of us as we get older in life, how we do things. And in the same way that gender bias in the courtroom has become a major focus, I'd say over the last 8 or 9 years, of entire court systems, and really looking to see how women, be they attorneys, be they court clerks, be they court reporters, be they female witnesses, were received in the courtrooms. I think that we're now at a point where we have to look at race again, and we have to look honest about it. I tell you, I'm doing some work in a few states. One state, which is an eastern state, when we went in to do the interviews on this particular site in court, the first thing we were told by the parents' attorneys was, this one judge turns his back, not completely, but just to the side to work on his computer when I put the parent on the stand. I mean, I'm from the West. That was shocking to me. And I asked another attorney. I said, is this possible? He said, well, only if they're people of color. He said he doesn't like poor people either. I couldn't imagine that. And it's not the kind of, it's what the gender studies to some extent pulled out, but it's the same model, it's the same kind of behaviors, it's the same kind of grounds for sanction. It is the nonverbal. What do we do in the courtroom from the bench? What do we do in the courtroom? And this is an extreme example, and I'm sorry to have to share it with you, and it's a true example. But what do we do from the courtroom? Judges have a responsibility to make sure that their attention is focused individually on that family, on that witness, on that person who's speaking in the courtroom, and that you have the time, you carve out the time to hear the case. It's not just the reality of being fair, it's the appearance of being fair. And I know that Judge Porter is saying, this is your courtroom. It's exactly the kind of example and the kind of example of judicial ethics in action that we really want to keep in mind and expect from every judge. Okay. Now the lawyers. Okay. These are some general admonishments from what's a preamble from the ABA Code of Ethics. You see them in most states. This is what a lawyer is supposed to do. Remember the first one before, that for the CASA must advocate for the child? A lawyer must always pursue the truth. A lawyer has responsibilities in each case and as a public citizen, and I particularly like the language here. A lawyer should seek the improvement of the law, access to the legal system, improvement of the administration of justice, and improvement of the quality of service rendered by the legal system. That is a mandate to look around in the courtroom and see how justice is being administered. And I'm meaning from a lawyer perspective, and I've practiced law for a lot of years, that means looking across the aisle, that means looking at my co-counsel and saying to myself, and maybe to them, don't you think maybe you should go see your client? Can we get together and get some more information? Are you having trouble getting records? There have been times, I think there's some pretty experienced attorneys in here, I'm just guessing here, but where you have had another attorney in the courtroom and you just had to shake your head. That's our obligation. Our obligation is not just to shake our head. Our obligation is to be smart about how we communicate, to be smart about what we do or don't do, to gather information, to perhaps counsel this attorney, maybe it's a new attorney. But we have an obligation. We have an ethical obligation to make sure that the quality of justice is not diminished, that we are constantly working to improve the quality of justice and maintain the integrity of the system. That's partly what we're all doing here today. It's partly what we're doing here today. Now, Louisiana's rules of professional conduct follow the national code that came out of the ABA. With a couple of exceptions, it's about 95% consistent. There's a couple of sections having to do with business that aren't included in Louisiana. The other exception is, you will see when you look, and I know you read this regularly, when you look at your amendments to the code, you will see that the only amendments made in the last 8 years had to do with inserting the word reasonable or reasonably for some of the specific language. For example, you shall be competent. It would say you shall be reasonably competent. Now, in lawyer construction, we know that that's always implied. But for some reason, the legislature thought it was important to include that language, and that's the only changes from the ABA model and what's the national model that you will see. Most of these are self-explanatory in the sense of these are principles we're all familiar with, whether we're lawyers or whether we're not lawyers. It seems that we've all heard this, we've seen enough stuff on television, just it's common parlance, if you will. The ones I'm going to focus on are competence, confidentiality of information, and conflict of interest. There's some red highlighted language that I want to say a little bit about. A lawyer's duty is not just to advocate, but a lawyer's duty is to be a counselor, an advisor as well. Now, what does that mean? We talk about counsel. Sometimes we'll use that as a synonym for a lawyer. My lawyer, my attorney, my legal counsel. Legal counsel, lawyer, attorney are all the same, obviously. But the use of the word counsel implies the duty of a lawyer to bring in more than just the black law, the letter of the law. To bring more than just the absolute letter, the Black's dictionary, if you will, version of the law, into their advice to their attorneys. The lawyer is required to bring in the life experience, information from all sorts of other sources, whatever is necessary to give the best possible counsel to that client. Organization as the client relates to an organization such as the district attorney's office and their special ethical obligations in representing an organization, which would be, in this case, OCS. There are special ethical obligations having to do with when you develop a conflict of interest and how you are to pursue that or how you must pursue that within that representation. You'll see that the rules go on. What we think about as being the core of an attorney's ethical responsibility is zealous advocacy. That's true, but there are a couple other cores to it, and it's not as simple as sort of fight blindly into the night. It's a lot more complicated than that. There are other features of the responsibility of a lawyer once he or she is in the courtroom that you'll see also in this list of rules. You'll see meritorious claims and contention. What does that mean? That means that you can't just object because you feel like objecting and because you like having your words on the record. Okay? Candor towards the tribunal. That means a responsibility to make sure the court has all the information it needs without violating your other obligations as an attorney, which are obligations to your client. Transactions with others. That is particularly, or those sections are particularly applicable here in this particular area of law because you have so many others. You don't just have other attorneys. You don't just have represented clients. You don't just have the judge or judges. You have that whole array of people, that whole United Nations in the courtroom. You have relatives, you have teachers, you have providers, you have psychologists, you have doctors, you may have a transportation officer, you may have a neighbor, you may have a foster parent, you may have an uncle, you may have an aunt. There are many, 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 many others. And even though you obviously are not attorney for them, you as a lawyer have ethical obligations in your relationship to them. It comes down to you must not take advantage of them by intentionally giving them false information that will cause them to say something prejudicial. It's very fact specific, it's very complicated, but there are ethical obligations in the way you transact business and the way you communicate with third parties, assuming we're talking about the unrepresented third parties. You can't talk to the represented third parties. Okay, I'm going to focus on three of these rules of professional conduct, canons, rules of ethics. Competence, confidentiality, and conflict of interest. These are the ones for which attorneys most often get disciplinary sanctions, for which attorneys most often cause cases or decisions or rulings to be overturned. These are the areas in which attorneys are most often sanctioned with probation and sometimes even beyond probation with losing their license. So, competence. 1.1. What I've put on here is an attempt to focus some concepts and some pieces of information that you will be familiar with because I'm really focusing on child in need of care and not overall competence. We expect a lawyer to know how to come into a courtroom and to know what the law is. In this particular area of law, it's much, much broader. Okay? In order to practice here competently, in my opinion, not only do you have to know Louisiana law, you have to know the federal law that generated most of what we have nationally as child welfare law. You have to know the regulations that were then promulgated as a result of that federal law, because no federal law comes without regulations where there's money involved, and there's definitely money involved in ASFA, and there's definitely money involved in the Children's Bureau, there's definitely money involved in how most of the child welfare law is translated into implementation in the states. Okay? So you have federal law, state law, regulations, you have OCS policy. I don't think you can be competent without knowing what the child welfare policy is, what the definitions are, what the forms are, what are the instructions to the social workers. Okay? You have the Child and Family Services Review coming up. You have another round early next year. You're right now in the middle of doing your court assessment and the statewide assessment. You all should be involved in that as stakeholders. You all should be participating. It's a tremendous opportunity to get a real in-depth view of how the system works, how it relates to the courts, what the standards are that the federal government, the Children's Bureau, is applying to social work practice. What is best practice? We talk about best practice in the context as if it's something pie in the sky. Lawyers should think about best practice as what is the standard of care. If you were cross-examining a doctor who delivered a child and something happened in the course of that delivery, you would be going to experts to ask them, what is the standard of care? Was the anesthesia properly administered? Was the blood quickly and in an efficient and appropriate way given to the mother? You would need to know what the standard of care is. And I'm suggesting to you in the same way, when we talked about the Child and Family Services Review here, when we talked about OCS policy and procedure, there are standards of care that should be the core of your cross-examination and your advocacy and your asking good questions. When you have a question, a legitimate question about how something was done, and you need to have your own experts to help you fully understand that, and I'm suggesting that's another resource that has to be in your bag of tricks in order to be competent in this particular area of law. The duty to provide competent representation applies to all clients, including children. We all know that. Okay? We all know that. There is 1.14 of the rules of professional conduct talk about children, but they talk about them as if they were adults with diminished capacity. Okay? Now it's gotten better. It's gotten better. The canons, at least at the American Bar Association level, really talk about representing youth. But really, that's where children and the representation of children and the ethical issues about children have been categorized. They're just like us, maybe a little bit shorter, maybe taller in some instances, but they're just diminished. They're not as capable as we are. And we could say they're not as mature. Okay? Now, we know about brain development. We know that there's some theories about how it continues throughout your life. I'm for that theory. I think your brain continues. Now, whether your frontal lobe and the judgmental parts of your brain really develop as early as we would like them to, what our role is in terms of representing a client when we take that into consideration, all of that is definitely relevant. But when it comes down to it, ethics requires that the same standard of representation be applied as if you would to an adult, and an adult for whom you are giving the best possible guidance as to their best interests. So it's more complex in some way. But fundamentally, all the effort that you're going to put into representing the interests of an adult is what ethically you're required to do when you represent a child. This is a case out of New York. And it's hard to find decisions in this field, though there are more and more. We have to look across federal regions and across federal circuits because this is a federalized area of law. So you should be able to, through the number of web-based searches that are available and the web-based services that just pop up on your screen, be able to get access to all federal court decisions and state court decisions having to do with adoption, TPR, and competent representation. So you should be able to quote and have available to you those cases when you need them. That's why I bring the case here from New York, which is one of the clearest statements about the standard of competency required and the comparison between adult and juvenile representation. I put this slide up and talked about kiddie court here because I wanted to be reminded that that's the way it used to be looked at. You know, I'm just passing through here. I'm a new DA, but you know, I have to pay my dues here for 6 months. Then I'm going to the real court. Okay, I don't think there's anything more real than this court. And I suggest to you that if you think the standards in any way should be less in terms of your practice in this, or there's such a thing as representation light, then perhaps you need to look at it again. I mean, these are the most profound decisions that any person or people can be involved in. Talk to any child who's in foster care and they will tell you how your decisions have impacted their lives. Talk to any child out of foster care and they will tell you how those decisions that were made in that courtroom, in their presence or most likely out of their presence, with their involvement or most likely without their involvement, have impacted their lives forever. So we're talking about having a sense of what is the level of competency, the level of advocacy that we're required or is required of us when we represent children. It's the same level as if we were representing an adult. Competency requires preparation. Preparation means outside the courtroom. Does not mean that quick little very familiar 5-minute conversation in the hallway. These are just two cases one case and a follow-up case having to do with competency of counsel related to preparation. I can give you about 24. I think you're going to see more and more of those opinions coming up. If you are not giving your client the same amount of attention outside the courtroom as you would any other client, be they adult or child, in these proceedings, then you are not properly prepared. You cannot present competent representation. The examples here, of course, is extreme. That's what gets to the appellate level. They should not be extreme before they get our attention. Preparation requires establishing a relationship with your client. How can you be prepared when you can't talk? How can you be prepared when you don't have a trusting relationship with your client? Let's talk about advocacy. Advocacy. We're talking about in the context of being prepared and competency in the courtroom. I want to make sure that we have a balance when we talk about advocacy. There's a few cases, and most in the area of attorney discipline, where they talk about advocacy going too far. Now, this particular case is the example of the attorney who was there, may or may not have talked to, let's see, guest did not in this case also interview the child in advance, but merely walked through the hearing, right? Or in this case, maybe sat through the hearing. Right? You've got to believe that the circumstances of this case were pretty egregious, pretty serious for this to have gotten to the appellate level as it did here. The case was vacated and was remanded, and it was a termination of parental rights. The impact of that attorney for the child not providing competent representation was not just on that particular ability of that judge to make the appropriate decision. That is an impact directly on that child. Things start all over again. The agency has to decide at the particular moment if there's a grounds for continued removal. The court has to decide if there's something to sustain any part of its rulings on based upon the hearing it had before that was not remanded. If it was remanded in total, you start all over from square one. Okay? Now, if you're lucky, you can get on your court calendar the next day. Odds are you don't get on. And odds are this appeal probably took a year. So the failure of other attorneys in that courtroom, the failure of that judge, frankly, the failure of the social worker or the CASA not to know that this attorney was really actively advocating for that child, that was communicating with that child, is a failure in all the system for which that child suffers, which is the one thing we all can agree on we really want to avoid. Now, I'll talk to you about zealous advocacy, but you're going to have to do that after, because this is Thomas Zawada, one of my favorite cases of, we call him the junkyard dog DA in Arizona. Let's talk about confidentiality. Okay? Confidentiality. That means that a lawyer is required not to disclose anything that would adversely affect the interest of his or her client, any communication, and for previous clients where your relationship is terminated, you've finished the case and you're not any longer representing them, you can in the future not provide any information that would in any way even arguably adversely affect the best interest of your former client. So when you're talking in the hallway to another attorney on the case, or you're talking to the social worker on the case about your client or something your client said, and it may not be you think the most material part of what was said, or it's something everybody knows, or it's just a casual conversation, it's not in the courtroom. I really want you to look at what the ethics of that is. It's hard when you're in a community where you know everybody. You know all the lawyers, you know the social workers, you know the providers, you know the CASA volunteers, you probably know some of the families. It's hard because it's informal, and we want a certain amount of that kind of communication to go on, because that's the way often things get resolved. That's the way good decisions are made. That's the way important information is shared. But you're standing there, you are the holder of some of the most private information that anybody ever has about another human being. Something they certainly didn't want you to know, and probably things that you don't want to know. You really don't want to know. And somehow in casual conversation, without intention, without sort of maybe with an understanding or a belief that, you know, we're all talking about the same issues, something comes out. That's a breach of confidentiality. I think it's one of the biggest ways in which we lose trust with our clients in these proceedings. Clients expect you to stand up and advocate them. They expect to see a lawyer doing lawyering. They expect to be able to trust that lawyer, and everything they say to him or her is really kept in confidence. To the extent to which we can maintain that relationship and build that trust, we can help that parent make the best possible decisions regarding whether or not they choose to reunify or not with their child, what needs they have, what issues that need to be brought up to the attention of the court to get more services, and whether or not they really are reasonable efforts being provided to that family and youngsters in order to remove those circumstances that brought them to the attention of the court. I'm at the end of what I'm going to say, but I'm going to take another minute just to do one quick thing here. And this is the second part, and I apologize for not getting here as quickly as I would have liked. A strategy on DMR, it's in the PowerPoint. And so you understand what I'm trying to say here, which is that each of the decision points, which I think are easily equivalent to findings in the child in need of care process, are points at which you have an opportunity for advocacy. Removal and reasonable efforts and contrary to the welfare are all decision points outside of the system and at the entry point of the system where you should be able, as an advocate, to get data on the disproportionate minority representation or raise the question about whether or not there is disproportionate minority representation at this time. If you can raise that question, if you can successfully show that for these same set of circumstances, more kids of color, more African American kids here are being removed, that their recommendations for removal are significantly higher or even arguably significantly higher or different for kids in arguably the same circumstances. If you can show that the same amount of effort was not made to keep those children at that home, the same amount of resources weren't brought in, they weren't put on the list for the home services, or they couldn't get on the list for the home services, or because of the delay in getting on that list, and we know we'd like to have everybody on that list, they couldn't get on. If you can show that there is some relationship, intentional or otherwise, then you've got some real issues to argue, in my opinion, regarding whether or not that removal was in the best interest of that child. You have contrary to the welfare, you have was it in the best interest. And your argument about reasonable efforts, which is the findings we all know the court has to make within 60 days to receive 4E money, your argument needs to go to that data. In the same way at reasonable efforts at permanency, it needs to go to the data. If you have trouble getting that data, that's why you're a lawyer. That's why you use a subpoena. Hopefully you'll have a discussion before you do it, but there's no reason to do it. You need to be able to get the information you need to have to advocate for your child or for your parent that decisions were not made on a totally objective basis, that there was in fact the subjectivity of race that entered this decision. The only way you can do that, unless somebody tells you, is by looking at the numbers. It's not comfortable. It's a way of helping us do our job better. I'm pleased to lead you over to my colleague. I'd very much like to talk to any of you if you'd like to pursue this issue of advocacy around DMR. I'm sorry I had to abbreviate this, but Ms. Cont'd is going to carry us on to professionalism.